the Q&A. We've received questions for all three speakers. I think, in the interest of fairness, perhaps I'll ask one question to begin with from each speaker, for each speaker. Let me start with Professor Martinek. Sorry, give me 1 second to find the question that I had here. The question for you is from Professor Liu Chao, who asks, as a matter of methodology, how do you see the balance between keeping to one's legal tradition and comparative leanings from other jurisdictions in search for a solution for new problems?
Can you hear me now? Wonderful. Yes, I think that is really a fundamental question of methodology of comparative law, no doubt. I mean, we all have had our legal education in our own legal system and have a certain tendency of coming home always, and we in a way are stuck in our own tradition. It is not so easy to surmount these impediments of totally getting involved empathetically in another system. I can tell you in my own educational history, I always had a deep, let's say, difficulty in finding my way into the common law thinking. You remember the speech of Professor Gallagher today, this differentiation between law and equity and all its subtleties. It is, you know, not just a matter of intellectual comprehension. It is also a matter of feeling, and you must live in that for maybe many years to actually see what it is all about. And that, of course, it does not really facilitate the life of the comparatists when trying to learn from each other. It's not really so easy to always take into account the sometimes really totally different way of not only systematical thought, but also of, one can say, legal mentality. You see, of legal mentality. Despite the language problem, by the way, despite the language problem, I see with great, let's say, anxiety that so many comparatists from common law countries have little inclination to get involved with a German law, mainly because they have no access to the language. Sometimes they don't like the people. There are good reasons for the one and for the other, but you know, one could indeed learn a lot if one can also try to learn foreign languages. And insofar, I think your question amounts to a fundamental methodological issue. We need probably a universal transnational methodology for comparative law thinking, which has not yet been developed properly. The comparative law is always still embedded in the national law, and the people look from their own country cross-border to other sites. There is no truly inherent international, globalized methodology regard to comparative law thinking. And I think it's one of the major tasks, perhaps, of this new Center of Transnational and Comparative Law to contribute to the development of such a methodology. As long as we don't have it, I cannot appropriately answer your question.
Fair answer and quite a task you've given us. Thank you for that. Let me move on to asking a question of Professor Gallagher. This is a question from Tang Hang Wu, who asks, do you think that Lord Burroughs will now reframe the change of position defense from being expressed in inequity. His textbook seems to rationalize change of position on disenrichment. There's more, and none of this makes any sense to me, but I'm happy to read more. Similarly, do you think that Justice Edelman will reframe change of position on the principle of irreversibility? That would be consistent with the view expressed in Edelman and Bent.
Thank you very much. Well, I can see Professor Martinek is looking. He'd like to answer this question as well. I think maybe Professor Wolf later on is going to touch on this this issue as well. It's very difficult to say what any judge will do in the future, even when they have written things extrajudicially. But I would expect, obviously, that Lord Burrows will be introducing some of his ideas into the common law. So I would expect that to happen. We've already seen many judges adopting many things that Lord Burrows has said in other areas, for example, to do with illegality. So it probably would be a follow-on. That's all.
Okay, thank you. And then a question for Dr. Lutman from our dean, Professor Lutz Christian Wolf. It has been said that for the whole of German law of unjust enrichment, paragraph 818, para 3, is the most important rule, because no other remedy, for example, in contract or tort law, allows the defendant to escape liability in this way. Do you agree? In your view, is it the same for the change of position defense in common law systems?
Thank you for the question. In German law, due to this principle of abstraction, the law of unjustified enrichment comes into play quite often, actually, in contrast to other civil law systems with the principle of causality, such as, for instance, Swiss law or Slovenian law. And I believe that similar is also the position in English law. But moving to the question of whether the disenrichment defense forms actually a central part of the law of unjustified enrichment in Germany. In my opinion, this as I've already mentioned, this defense is defined rather restrictively also in German law. So it should be, the defendant should prove that he is no longer enriched, and disenrichment should be actually, this disenrichment should be overall disenrichment. So no enrichment in any form whatsoever should be left in the defendant's hands. So in my opinion, this is rather difficult to prove also, as I've observed in Slovenian law. This defense was criticized by many scholars around the world, but as I've made a research of German law, I could say that it is not invoked so often in practice. But maybe I can also leave some comments for Professor Martinek coming from a German legal order.
Yeah, if I may also try to answer the question. I think it is one of the major achievements lately to make very, very subtle and intricate differentiations with regard to the defense of disenrichment or impoverishment, and particularly link this defense to the taxonomy or categorization of different types of claims of unjust enrichment. After all, this defense is based on trust. The defendant should be worth protected, he trusted rightfully, and comprehensibly would trust on retaining the asset and not to have faced a unjust enrichment. In this trust, he should, in many cases, be protected. This is particularly the case in those types of unjust enrichment claims based on a performance in the connection of a seeming or erroneous contractual relationship. Here, normally, in many cases, the defendant is in bona fide and relies on the retainment of the retention of the asset. And in so far, he can raise then the defense of impoverishment or of disenrichment. Whereas in cases of claims based on wrongful intervention, even if the defendant is also probably in bona fide, in good faith in this respect, that are closer to delictual claims, the defense must be very, very much restricted because, as Dr. Luttmann pointed out rightfully, in those types of unjust enrichment claims, we are more concerned with the compensation of a loss than with the disgorgement of an enrichment. And here the entire functional ability of the enrichment claim changes a little. So I think it is a major task to develop this differentiated system further on. Certainly, Professor Wolf is right when emphasizing that this defense is in the center of the entire unjust enrichment claims, because in a way it defines the restriction and the limit of the liability. And he's also perfectly right in stressing that no other type of liability knows anything, hardly any other type knows something comparable. But we must have a very, very certainly restrictive view on that. Dr. Luttmann is perfectly right, but because of this exceptional situation, it must be restricted. Secondly, we must have a differentiated look depending on the different types of unjust enrichment claims.
Thank you very much, Professor Martinek. And thank you all to three speakers for a really, I think, interesting and exciting panel. Thank you all for your questions. We have now come to the end of panel session 1. We'll take a 10-minute break, and panel session 2 will start at 3:45 p.m. Hong Kong time. Thank you all again.